And we are now 284 days away from the midterms. Today, for the first time, former DOJ special counsel Jack Smith testified publicly about his investigation into Donald Trump in the aftermath of the 2020 election. Watch this.
I stand by my decisions as special counsel, including the decision to bring charges against President Trump. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in criminal activity. If asked whether to prosecute a former president based on the same facts today, no one should be above the law in this country, and the law required that he be held to account. That statement is consistent with what we found in our investigation, in that our investigation revealed that Donald Trump was not looking for honest answers about whether there was fraud in the election. He was looking for ways to stay in power.
A federal judge just dropped a massive ruling in the Epstein files fight, and Trump's administration is scrambling. Multiple judges are now putting serious legal pressure on the Justice Department over those files. The documents everyone's been demanding, the records Trump promised to release, the materials that could expose powerful people's connections to Jeffrey Epstein. And these judges are not playing around anymore. They're rejecting the DOJ's delay tactics. They're ordering expedited processing of oversight records. They're calling out attempts to use the courts as a diversion from actual disclosure. And they're making it crystal clear that if the Epstein files stay hidden, it's because Trump's administration is choosing to hide them. The courts are throwing responsibility right back at Trump and Attorney General Pam Bondi and saying, you have the files, you have the power to release them, so stop making excuses and do it. And now Congress is moving toward contempt proceedings because the DOJ released less than 1% of the files by the legal deadline. 1%. After Trump signed a law that passed 427-1 requiring full disclosure. And judges are systematically dismantling every excuse the administration has used to avoid transparency.
When people told him things that conflicted with him staying in power, he rejected them.
Do you believe that President Trump's Department of Justice will find some way to indict you?
I believe that they will do everything in their power to do that because they've been ordered to by the president.
And as if on cue, President Trump immediately posted that based on Smith's testimony today, he should be prosecuted for, at a minimum, quote, large-scale perjury. And if right now you're screaming at your TV, for what? I screamed the same thing, too. And the answer, Republicans accuse Smith of interfering in the democratic process by trying to muzzle a presidential candidate. But here's the thing. They did not produce any new evidence that supports that argument. Congressman Darrell Issa accused Smith of spying for seeking a court order for phone records of 9 Republican senators.
Here's what's happening. Back in November 2025, a progressive legal group called Democracy Forward sued the Justice Department over the Epstein files. They filed a FOIA request, Freedom of Information Act, asking for internal records about whether Attorney General Pam Bondi misled the public because Bondi went on TV and said the Epstein client list was on her desk, ready to release. She made this big show of saying full transparency was coming, and then she abruptly reversed course. The files didn't come out, the client list didn't get released, and people started asking what changed. Did someone get to her? Did Trump intervene? Did powerful people connected to Epstein pressure the administration to back off? Democracy Forward wanted the internal communications that would answer those questions, and the DOJ slow-walked their request, just ignored it, treated it like any routine FOIA that might take years to process. So Democracy Forward went to court, and Judge Tanya Chutkan, the same judge who's been handling Trump's January 6th case, ruled in their favor. She said this request meets the legal standard for expedited processing. She said it concerns a matter of widespread and exceptional media interest. She said it raises possible questions about the government's integrity that affect public confidence. And she ordered the DOJ to process the request faster. Stop dragging your feet. Start producing these records. The public has a right to know whether the Attorney General lied about releasing the Epstein files and why the administration changed course. That's a huge ruling, because it means the DOJ can't just bury this FOIA request in bureaucratic delay. They have to actually respond. They have to produce records, and those records could expose exactly what happened behind the scenes when the Epstein file release got shut down. But that's not the only ruling putting pressure on Trump's DOJ. Judge Richard Berman, the judge who's been overseeing Epstein-related cases, rejected a Justice Department motion that he called a diversion. The DOJ came to him asking permission to release limited Epstein grand jury records, just 70 pages. And Berman looked at that request and said, this is a distraction. He pointed out that the government already controls roughly 100,000 pages of Epstein-related materials that they could release without any court permission. The DOJ doesn't need a judge to authorize disclosure of those files. They can just release them. But instead of doing that, they're coming to court asking about 70 pages of grand jury material, like that's the whole issue. And Berman shut it down. He said the logical party to disclose the Epstein files is the Trump administration itself. He noted that DOJ previously promised to make those records public. And he made it clear that focusing on a tiny slice of grand jury material while sitting on 100,000 pages of other documents looks like an attempt to avoid broader disclosure obligations. So you've got two judges, Chutkan and Berman, both calling out the Justice Department for trying to hide behind procedural excuses instead of actually releasing the files. And then on January 21st, 2026, there was another ruling. Two members of Congress, Representatives Ro Khanna and Thomas Massie, went to court asking for an independent monitor to supervise the DOJ's compliance with the Epstein Files Transparency Act. They wanted a court-appointed watchdog who could force the administration to follow the law. And the judge said no. He ruled that while lawmakers can sue to enforce the law, they can't install a judicial monitor over DOJ's exercise of its discretion. But here's the important part. Even while denying that request, the judge acknowledged that DOJ's slow partial release has sparked serious public concern. He basically said, Congress, you have your own tools to enforce this. Contempt, oversight, political pressure. Use them. Don't expect the courts to babysit the executive branch. And that's exactly what's happening now. Congress is moving toward contempt proceedings against Pam Bondi because the DOJ completely blew the deadline. All right, so let's dig into the Epstein Files Transparency Act and why these court rulings matter so much. Because understanding the legal framework is crucial to understanding why Trump's administration is in such a bad position right now. The Epstein Files Transparency Act passed the House 427-1. 427-1. That's about as bipartisan as anything gets in modern Congress. One single member voted against it. Everyone else, Republicans, Democrats, progressives, conservatives, all voted yes. Then it passed the Senate by unanimous consent, not a single objection, and Trump signed it into law on November 19th, 2025. Now, why did Trump sign a bill that could potentially expose his own connections to Jeffrey Epstein? Probably because vetoing it would have looked even worse. Congress could have overridden the veto easily with those kinds of margins, and refusing to sign would have made it look like Trump had something to hide. So he signed it and probably figured his Justice Department could find ways to slow-walk compliance or release heavily redacted versions or otherwise minimize the damage. But the law is really specific about what has to happen. The Justice Department has to post Epstein case files publicly within 30 days, and they have to give Congress an unredacted list of all officials and politically exposed persons named in the files. That's not optional. That's not up to DOJ discretion. That's what the law requires. Congress said we want full transparency on who was connected to Epstein, who's named in these documents, who potentially had relationships with a convicted sex trafficker, and they gave DOJ 30 days to make it happen. So what did DOJ do? They released less than 1% of the files by the deadline. Less than 1%. Out of roughly 100,000 pages of documents, they put out maybe a few hundred pages, mostly stuff that was already public or heavily redacted. And they completely ignored the requirement to give Congress an unredacted list of names, just didn't do it, and that sparked bipartisan outrage. Because this wasn't a close vote where one party barely won and the other party is mad about losing. This was 427-1. This was unanimous Senate consent. This was as close to universal congressional agreement as you ever see. And Trump's DOJ just said, yeah, we're not going to follow that law. And that's where the contempt push comes in. Members of Congress from both parties are now talking about pursuing contempt proceedings against Attorney General Pam Bondi. Some are calling for inherent contempt, which is this old congressional power where the House can literally fine someone or even detain them for refusing to comply with congressional demands. Others are pushing for a formal contempt of Congress resolution. Either way, the message is clear. You're not above the law. You don't get to just ignore legislation that passed overwhelmingly, and there will be consequences for blowing off congressional requirements. And these judges are making that position stronger by systematically rejecting every excuse DOJ has tried to use. Judge Chutkan's ruling on the FOIA request is huge because it means the DOJ has to produce internal records about what happened with the Epstein file release. Why did Bondi say the client list was on her desk and then nothing came out? What communications happened behind the scenes? Who made the decision to reverse course on full disclosure? Those records will answer those questions. And DOJ can't just sit on that FOIA request for years. It's been designated for expedited processing. They have to respond quickly. And Judge Berman's ruling about the grand jury motion is equally important because it exposes the strategy DOJ was trying to use. They were going to go to court and make a big show of asking permission to release 70 pages of grand jury material. And then when the judge said no or imposed restrictions, they could point to that and say, well, we tried, but the court won't let us release stuff. It would have been perfect cover. They could blame the judiciary for the lack of transparency. But Berman saw right through it. He called it a diversion. He pointed out that 99.9% of the Epstein-related documents DOJ controls aren't grand jury material at all. They're case files, investigative records, correspondence, witness statements, stuff the department can release without any court approval. So coming to him about 70 pages of grand jury material while sitting on 100,000 pages of other files is just an attempt to create the appearance of transparency while avoiding actual disclosure. And Berman wasn't having it. He basically told DOJ, if you want to release the files, release the files. You don't need me. You don't need court permission. You're the logical party to disclose these records. So stop trying to hide behind judicial procedure and just do what Congress told you to do. And then the January 21 ruling about the independent monitor adds another layer, reps. Khanna and Massey went to court saying we need a judicial watchdog over DOJ because they're not complying with the law. We need someone with enforcement power to make sure these files actually get released. And the judge said, that's not how this works. The judiciary can't install a monitor to supervise the executive branch's day-to-day compliance with legislation. That would violate separation of powers. Congress has to use its own tools, oversight hearings, contempt proceedings, appropriations, impeachment if necessary. But the judge's reasoning is important. He didn't say DOJ is doing a great job and Congress has nothing to worry about. He acknowledged that the slow partial release has sparked public concern. He basically validated Congress's complaints while saying you need to handle this through political and legislative mechanisms, not judicial supervision. And what that means practically is Congress can't outsource this problem to the courts. They have to own it. They have to use their contempt power. They have to hold hearings. They have to publicly pressure the administration. They have to make Bondi testify under oath about why the files aren't out. And all of this puts Trump in a really uncomfortable position because these judicial rulings eliminate his excuses.